Hi everyone and welcome back. In the next 3 clips I will talk about the law of armed conflict or international humanitarian law, as it is also often referred to. To clarify this right from the outset, I use these two terms pretty much synonymously, and as does Klabbers in the textbook. Both of them describe the use in bello, which can be juxtaposed to the use ad bellum, so the law that is applicable to beginning hostilities to starting an armed conflict, and that of course we covered last week when we talked about the use of force, the prohibition of the use of force, and the UN collective security system. In the clips that follow, I'll really focus on the essential concept, so I will leave out pretty much the historical background that is described by Klabbers in the textbook and get right into the law of armed conflict as it is applicable today. In the first clip, I'll talk about the two notions of military necessity and humanity. In the second one, about the principles of distinction and proportionality. And in the third and final video, we will address the topic of non-international armed conflict. A good place to start a discussion on the law of armed conflict is to have a look at the main instruments that are operating in this domain. And these specifically are the 4 Geneva Conventions that were adopted in 1949, and you can see them here next to me and their titles specifically. They cover, as you can see, a wide variety of issues, starting from how to care for the sick and wounded, both on land and on sea, but also the topics of prisoners of war and the treatment of civilians during armed conflict. As I've done before in this course, I would strongly recommend that you have a look at these conventions to just see how extensive, comprehensive, and also technically detailed they are in outlining what combatants can or rather cannot do as they engage in hostilities. Next to this, we have 3 additional protocols to the Geneva Convention, and you can see them once again next to me here. Of these 3, the second one is particularly important because it relates to the rules that are applicable during non-international armed conflict. So, for example, during civil wars, and of course, these kinds of internal conflicts have become much more prevalent over the course of the 20th and now 21st century. I'll address these kinds of conflicts and the rules that are applicable to them in greater detail in the third clip. And finally, we have customary IHL, which is forgotten sometimes as a source of the law of armed conflict, but mistakenly so, because we know, of course, that customary law is just as binding as treaty obligations are as well. And customary IHL rules pertain here to those norms that, while they might be written down in some of the treaties that I've mentioned before, exist independently of those instruments and are therefore applicable also to those states that are not a party to these treaties. And these rules of customary IHL are quite noteworthy because we can find them quite explicitly outlined on the website of the ICRC, the International Committee of the Red Cross, which has done the work for us and has established state practice and opinio juris by looking at all kinds of documents, from military manuals to the decisions of military tribunals, in a very meticulous, detailed fashion, so we can actually find very specific customary rules here that, while not strictly speaking codified, are still assembled by a highly authoritative organization that has historically worked in the domain of IHL and carries a lot of weight also in a legal sense. Now, there is no point in me trying to use these short clips to go one by one through the dozens of rules that exist under both treaty and customary IHL. What I would like to do instead is to provide you with an overview, to give you some general guidance regarding the overarching principles that are operating in this domain. And based on that, I think you will be able to understand and navigate much better the specific technical rules that you will find in the various instruments. Now, on the most general, abstract level, the law of armed conflict was created as a compromise between 2 arguably quite contradictory principles, namely, on the one hand, the principle of military necessity, and on the other hand, the principle of humanity. Military necessity in a belief, looking at the history of humanity, that war will always happen, even if we wish it were otherwise. And many proponents of IHL, people working in the field, will hold such a belief and will therefore also accept the idea that we need to respect the military aims and objectives that states or other entities, for that matter, are trying to pursue and that lead them to go to war in the first place. The only thing that we can do if we follow this ideology that underlies IHL is to make a terrible situation a little less worse and to ameliorate the suffering by civilians, combatants, the sick and the wounded, and this precisely is what is encapsulated in the principle of humanity. In a second, I'll explore in greater detail what these 2 principles entail. But what you need to understand as a next step is that there's a third principle, the principle of proportionality, that mediates between the two, in the sense that any operation that pursues something of military necessity, any kind of military objective and goal, needs in fact to be proportionate, needs to take into account the other principle, the principle of humanity, and the two need to be in a sort of balance. Obviously, this plays out in quite specific ways in different provisions, in different conventions, and in the customary rules, but what you need to remember is that there are these two opposing forces that pull in opposite directions. The final central principle of the law of armed conflict is the distinction principle, and I will discuss this in greater detail in the second clip. For now, it's safe to say that it is the distinction basically that any combatant needs to draw between another combatant on the one hand and civilians on the other hand. Final important question is when IHL is triggered. When does it come into force? And the answer to this question is when there is an armed attack. A little bit like last week when we talked about the use of force, the term war has fallen out of fashion. And that is because nowadays IHL includes declared and undeclared wars. The really important thing is that materially speaking, there are hostilities. Materially speaking, there are different combatants engaging in fighting, and that is what makes the difference in this regard. Partial or total occupation of the territory of one of the state parties is another condition in which the law of armed conflict comes into force. And finally, there is the distinction between, on the one hand, international armed conflict, IX, and non-international conflict, NIAX, to which these rules are both applicable, but as we will see in the third clip, the rules that pertain to NIAX are somewhat different. Note, and this might be a moot point that is obvious to you, that all of this needs to be distinguished from law enforcement, notably through the police forces in peacetime. The law of armed conflict really only comes into play when there is armed conflict, and as we'll see in the third clip, there's a specific threshold that needs to be met for internal kind of strife to reach that sort of quality. Now, to end this video, a few words on the principles of humanity and military necessity. The principle of humanity can be found in the 6th Hague Convention of 1907 in what is usually referred to as the Martens Clause, which constitutes a sort of baseline below which no action that is taken by a military should fall, and that is a default backup option when there is no specific rule that is available. So, to cite the article, it stipulates that until a more complete code of the laws of war has been issued, what offers protection are the principles of the laws of nations as the result from the usages established among civilized peoples, from the laws of humanity and the dictates of the public conscience. Now, this is obviously quite broad, but once again, the specific provisions can be found in the various instruments. But what is important here for the Martens Clause is that it reaffirms the general principle of humanity, referring in an almost natural law kind of way to the dictates of public conscience as well. By contrast, and I will end with this, there is the notion of military necessity. And I think by now, by the end of this video, you have understood that this entails any kind of military consideration, any kind of military strategy, any kind of targeting of a military objective, something that will give you an advantage in the armed conflict. That is what the notion of military necessity refers to. And of course, the whole point of the law of armed conflict is that these actions do need to be taken in a way that they do respect law of armed conflict and do not in a disproportionate way violate the principle of humanity. As a little side note, and you will see the relevant text here next to me, the UK, but also many other state parties to these treaties, in this case the additional protocol number 1, have clarified that military necessity refers to the military advantage that can be anticipated from the attack as a whole, rather than to an isolated or particular part of the attack. This concludes this first video. In the second one, I will talk about the other two main principles of the law of armed conflict, namely the principles of proportionality and distinction.